Hello everyone and welcome to the program. This is Politics Today live on Channels Television. I am Kayode Okikiolu sitting in for Seun Okimbaloye. What a week it has been. First news of electricity tariff hike, and now with the petrol price hike, Nigerians are wondering just what more this week can throw at them. Well, there's some sort of reprieve. You can call it a silver lining coming from outside the country with a judgment of the High Court of Justice, Queen's Bench Division Commercial Court in the United Kingdom. But before we get into that, let's bring you the reactions of some civil society groups who have taken to the streets of Osun State to voice their displeasure over the recent increase in the price of premium motor spirit, also known as petrol, and electricity tariffs. As you can see, they were carrying placards with various inscriptions, and they're demanding a reversal of the increments. And just to show how serious they are, they have given a 5-day ultimatum for these decisions to be reversed. If this is not done, they are threatening to return to the streets on a full scale. Listening.
We are here because Buhari has failed Nigerian citizens. We are here because he has putting more pressure on the already impoverishing Nigerian citizen. We are here because we say no to increment in kilowatt of electricity in Nigeria. We are here because we say no to incessant increment on the pump price of petroleum products in Nigeria.
We are here today to tell them that we own the land. It is not the property of Buhari. It is the masses of our people that elected them. And they were elected based on certain promises which they have failed to fulfill. Now, we are here today to protest and give them 5 days ultimatum, 5 days notice to rescind this decision or face the wrath of the people.
We felt the government would be magnanimous to be good to us. Unfortunately, today, we are just coming out of pandemic, and the gift for pandemic is increment in fuel and kilowatt of electricity. Today, Nigerians are highly disappointed because, like I said, majority of us came out to join the occupied Nigeria against a President Jonathan. And today, we have been given worst of what a President Jonathan gave us in this country.
Well, there you have some of the issues. But tonight on the program, we'll take a deep dive into the latest judgment on the P&ID contract. 43 pages of a judgment which has just been delivered. Well, it's a major win for Nigeria, according to legal practitioners, and we'll tell you why in a moment. But first, we'll take a look at other matters making the rounds in the nation's political landscape. And here's our political roundup.
A coalition of northern groups has kicked against the recent increase in the ex-depot price of petrol and electricity tariff by the federal government. The group is demanding for the immediate and unconditional reversal of the new petrol pump price to the earlier one of 145 naira per litre and the electricity tariff to 23 naira with the assurance of regularity and quantity of supply.
The accepted universal practice is for governments to subsidize costs of essentials in line with citizens' purchasing power. The Nigerian government rather provokes more hardship on the population with inconsiderate, unregulated, harsh economic and financial policies.
President Muhammadu Buhari has endorsed the incumbent governor of Ondo State, Rotimi Akeredolu, for a second term in office and has charged party leaders to ensure that Ondo State remains an APC state after the upcoming elections. Mr. Akeredolu was presented to the president by the APC Campaign Council for the Ondo State governorship elections. The governorship candidate, Mr. Akeredolu, says he was delighted with the warm welcome he received from the president and is confident of his victory in the upcoming polls. Rotimi Akeredolu says he still has many projects he intends to complete if he wins the elections in October. And the Inter-Party Advisory Council has inaugurated a 4-man national interim committee that will pilot the affairs of the council over the next 4 months. The immediate task of the committee, which is headed by Chief Ralph Mwosu of the African Democratic Congress, is to reconcile members of the council and ensure a democratic transition to a new National Executive Council. The tenure of the outgoing president, Chief Peter May, expires on September the 5th. Addressing journalists after the inauguration, Chief Nwosu explains that the council will review the code of conduct of members.
We are going to reconcile parties. We are going to reconcile parties among themselves. We are going to reconcile parties with government. We are going to reconcile the systems, the judiciary. This body should have developed code of conduct so that the system doesn't degenerate.
So let's get into our major topic for tonight. The federal government's bid to overturn the $10 billion judgment awarded against it in a case against BNID has been given the much-needed green light. As a judge of the Business and Property Court of England and Wales, Ross Cranston has granted Nigeria's application for an extension of time and relief from sanctions. Now, let me show you a statement from the Office of the Attorney General of the Federation and the Minister of Justice saying the court has allowed the Federal Republic of Nigeria to bring this challenge well outside the normal time limits due to the exceptional circumstances where the Federal Republic of Nigeria has uncovered evidence of a massive fraud in procuring the award. The statement goes on to say the court heard evidence from the Federal Republic of Nigeria and the offshore shell company PNID in relation to the gas supply and processing agreement as GSPA, which the parties entered into 10 years ago and which was never performed. And the statement goes on. But the good news from this is the fact that Nigeria has gotten the much-needed boost to pursue this case. But you know what? It didn't start today. It didn't start yesterday. And just to give you a sense of how we got here, let's go back in time for a moment and show you the major timelines in this P&ID case. Now, the company in the center of this all, that's Process and Industrial Development, P&ID, was incorporated in the British Virgin Islands in 2006. And fast forward to 2010, a GSPA was entered into between Nigeria and P&ID. Well, a lot of issues along the way. On August 22nd, 2012, P&ID sent a notice of arbitration to Nigeria to commence proceedings under the Nigerian Arbitration and Conciliation Act 2004 because, of course, the contract never took off. Fast forward 5 years after, a UK arbitration tribunal awarded P&ID $6.6 billion plus interest. And that got a lot of Nigerians shocked. $6.6 billion 2 years after a UK commercial court converted this arbitration award to a legal judgment which will allow P&ID try to seize Nigeria's international assets worth $9 billion. I mean, this went on and on. September 26th, a UK judge allowed Nigeria to appeal the ruling on the P&ID case, but then ordered Nigeria to pay $200 million. You may recall that. And Nigeria was asked to pay within 60 days to ensure stay. But Nigeria appeals this $200 million in November 20th, 2019, for, of course, stay on asset seizures. And eventually, Nigeria had to pay $200 million guarantee for stay on asset seizures. And then, December 6th, Nigeria started business, filing a fraud allegation case in a bid to overturn this $9 billion P&ID award. And today, it has culminated in the UK court allowing Nigeria more time to appeal the $10 billion dispute. I mean, this has spiraled into this. But let's get into the major issues. We have Mrs. Juliet Ibeka-Kunwagu, who's a special assistant to the President on Justice Reforms and International Relations, Office of the AGF. She joins us from our Abuja studio this evening. Good evening, and thank you for joining us. Also joining us via Skype is, good evening, is Barrister Akin Ajibola, international commercial lawyer and arbitrator who for over 19 years has been involved in cases of foreign investment and joint venture, oil and gas, and much more. Good evening, and thank you for joining us on the program as well. Well, let me begin with Mrs. Ibeka-Kunwagu. Well, the basics, really. What does this judgment mean in simple terms for Nigeria?
Thank you very much. What it means essentially is that Nigeria will have time to be able to argue this case, the substantive case in court. Essentially, the substantive case will be to request the court to set aside the earlier judgment awarding $6.6 billion against Nigeria and in favor of P&ID. So today we are happy as a government that we're able to present our case for the English court to have taken the view that there is a prima facie case of fraud is significant. And we need to be able now to put together all the reports of the investigation going on in Nigeria, in the US, and in several other countries in order to really show the court that this contract in the first instance was based on fraud. And I think this is where this case is going to be going to in future.
You know, you have just given us a scale of this particular proceedings, I mean, across countries, across years. And for people looking from outside, they might not really understand the import of this. How did we get to this point? How did Nigeria play it right to at least have gotten this round one victory in court?
You recall that after the Attorney General of the Federation went to London to make the first case, and Nigeria was then asked to deposit $200 million as a security fund, it became clear then that the English court was going to hear Nigeria. And hearing Nigeria meant that we needed to request for extension of time. You may also recall that P&ID also objected to the extension of time. They stated that Nigeria was already out of time because Nigeria failed to appeal all this while. On the basis of this, Nigeria also went out to undertake investigations. Remember that some of the officials of P&ID have been arrested recently. One of the lawyers or director of legal then was also arrested, and she's currently facing prosecution in Nigeria. We're also working closely with our U.S. counterparts in investigating some of the actions, or if you like, some of the internal fraud that occurred, meaning that there were insider dealings, money exchanged hands, and Nigerian government is now trying to unravel all of that and present that report to the court.
Okay, we'll try to, just a moment.
Based on their judgment today.
Right.
Yes. Just
a moment. We'll unravel these issues in a moment, but I think it would be fair to bring Mr. Ajibola in just to get his opening thoughts on this. Now, Mr. Ajibola, this has been described as unprecedented. Now, that's a term that is thrown around a lot, but as a legal practitioner, you've been involved in cases like this. Just how unprecedented is this?
Oh, well, unprecedented is a good term with respect to the fact that arbitration prides itself on finality. And the idea of having an arbitral award pending for 4.5 years, maybe some 5 years after it has been issued, is not something that the UK courts, based on the policy of the finality of arbitration, is not something that they look to lightly. So most cases in this regard, where the issue of illegality has been raised one way or the other, are put to the very strictest proof. The test and the bar is indeed very high. So Nigeria has gone back and has raised under Section 68(1) and 2 of the Arbitration Act that there's been a serious irregularity which borders on issues of fraud. What the court has looked at is not making a determination of whether that fraud actually occurred, but as the previous speaker said, a prima facie case, a strong case, a high likelihood that there have been instances of fraud. And that already speaks volumes of the efforts and the success of the efforts that Nigeria is making in unraveling a lot of the very complex transactions underhand that went on for the procurement of the GSPA, that is the underlying contract for this transaction.
Right. Okay, you know what, we'll get into some of the issues, Nigeria's submission, the issues around, the Bureau of Public Procurement, the Federal Executive Council not being involved. Some of the specifics, we'll get into it, but we need to go on a break right now. Please stay with us. Welcome back, everyone. Let's get back to the conversation. Mrs. Juliet Kunwago is still with us on the program. She is a Special Assistant to the President on Justice Reforms and International Relations, Office of the AGF. She joins us from our Abuja studio, as well as Barrister Aki Ajibola, an international commercial lawyer and arbitrator. He joins us via Skype tonight. Well, thank you for your patience. Now, just before we get into, the next line of thought, I'd like to just show you Nigeria's case, really, just a breakdown of this judgment. First, if you look at the volume of the evidence and what was put up, some 34 bundles with hundreds of pages of evidence and thousands of pages of exhibits, basically. But Nigeria's case in this, which you have touched on earlier, that extension be granted as the GSPA, the arbitration clause in the GSPA, and awards were procured as a result of massive fraud perpetrated by P&ID, and that to deny Nigeria the opportunity to challenge the final award will involve the English court being used as an unwittingly vehicle of the fraud. Well, Mr. Zubeka Kunwago, now this is perhaps one of the major points Nigeria is presenting in prosecuting this case. Just how important is this?
Say this, that as of today, we have legal instruments setting out the procedure for entering into such contracts. In this case, those procedures were not followed. So that means something happened. You could say money exchange had. You could also say that, what we define as using your office or to obtain a private benefit could intentionally be considered a corrupt act. But let me add this, that when you look at the decision, which, like you said before, is very significant, is unprecedented, but now it's become the jurisprudence, because when it comes to fraud and corruption internationally, everybody wants to make sure that contracts of this nature is not based on fraud. And that is fundamental. And that is what Nigeria presented, that you cannot rely on a non-existing contract. Basically, because of the fraud, it doesn't exist in essence. So if you have a case and there is fraud, is already tainted, Nigeria is saying, we need to look at why this contract is tainted. We need to look at how we got where we are. And then maybe we can have a reason to determine whether this contract can stand. Let me also add that what the judgment also said today, two issues. One, prima facie case, that Nigeria could actually go ahead, that Nigeria has a case, has actually raised the case of fraud. And secondly, that Mr. Quinn, who is representing P&ID, also could potentially may have lied to the tribunal or to the arbitration or the arbitration panel when he presented the fact that they had a capacity to undertake the contract. But when you look at the documents they presented before the court, there is nothing to show that they had the capacity to undertake the gas contract. And so on the basis of this, the court would say, we have established a prima facie case, so let's allow Nigeria to present its case. It is an international movement, if you like, principles moving towards the fact that everybody now recognizes that international contracts must be based on integrity, it must be based on transparency, it must be based on accountability. And Nigeria, through the Office of the Attorney General, have established this fact. And we hope that going into the substantive case, that Nigeria would still win. And of course, this is really what we are praying for, because it's going to have an impact on our economic environment. Mind you that all this while, this whole issue about 9 billion and the rest of them have a way of going into, when international communities look at Nigeria's economic outlook, they look at how such an award could affect Nigerian economic environment. And so today, we're saying to the world that Nigeria has a case, and we will see how it all goes out, how it all plays out at the end of the day.
Okay, Mr. Jibola, part of the submissions of Nigeria is the fact that, the GSPA did not obtain the requisite authorization of the Bureau of Public Procurement or the consent of either the Federal Executive Council or the ICRC, that's the Infrastructure Concession Regulatory Commission, nor was it registered with the National Office for Technology Acquisition and Promotion. And one begins to wonder, so if all that didn't happen, then what's the point of all this really?
So you make the point quite well. The issue is that transactions of this nature have a procedural rigor that they ought to have gone through before being signed or executed by the requisite and the correct authorities within the Federal Republic of Nigeria. You now find a situation where a transaction of this magnitude did not go through statutory dictates of the BPP, did not go through the requisite presentation at FEC for its approval, registration by NOTAP. You then find within the judgment specific allusions that those who were supposed to be the gatekeepers, those who were supposed to have effectively ensured that these rigors were adhered to, were perhaps part of a huge conspiracy on bribery. There was evidence that these people were paid money and took money. There was evidence that those who were leading Nigeria's charge on this matter were involved in payments. And the EFCC investigation has unraveled effectively that it might have been that this was part of a grand-scale attempt at fleecing the country on a transaction that could not have stood the test of propriety at all.
When you think about the quantum of the amount, $10 billion, I mean, it's huge. It's a huge percentage of our GDP alone. But another clause in this whole defense of Nigeria is the fact that the location of arbitration was also quite questionable. The Attorney General referred to an agreement saying that arbitration should have their seat in Nigeria. How does that come into play really in arbitrations such as this?
So indeed, there was reference to a circular that had been issued within government at that time with the aim of promoting Nigeria as a seat for arbitration, that when we draft agreements and we want to situate the seat of the arbitration, we should put it in Nigeria. However, in this particular instance, the seat of arbitration was put in the UK. And this was part of the issues that maybe caught Nigeria short, because after the initial award was given, and we launched, I think about 4 months or so thereafter, we launched an initial attempt to set aside the award in the UK. That attempt was rebuffed and it was not successful. We then came and filed an action here in Nigeria to set aside the same award, but the courts found that the seat of the arbitration was in the UK, and so it was the UK courts that had jurisdiction. And so for that very reason, we were not able to take advantage of the benefit that we would have had the seat of arbitration been made to be Nigeria. So these were some of the things that were found to be wanting in the process, that the whole transaction and some of the clauses that were agreed to in the way those matters were dealt with under the agreement, and found to be outside of the very strict dictates that government had put down at that time on how arbitration clauses should be dealt with.
Right. So on a final note, Mrs. Ebeka Kunwagu, you said you've done investigations, extensive investigations, and I believe they're still ongoing. Now, looking at P&ID, would you say they have a track record of this sort of dealings? And can the company be referred to as a shell company?
Well, that's already established. Even when you look at where they are registered in British Virgin Islands, that's one of the offshore centers or offshore financial centers that we would normally be very suspicious about. But let me put it this way, that there was never an intention to execute any contract. And that is really the intent to defraud is really the reason for that prima facie evidence established by the court. So this is the way we would say that it was really a sham vehicle established for the purposes of defrauding Nigeria in this case. And I also mentioned that we are seeking mutual legal assistance from several countries with regards to monies that were paid out to different individuals.
Right.
I can't speak so much about that until the final report is in place. But most importantly, let me just say that what is important today is that this will really enhance the economic outlook for Nigeria. It will help Nigeria's credit record, and it will help businesses or Nigerian businesses to also attract more investment. That is really what is key today, while we now pursue the substantive hearing of this matter.
Well, we know that this is not the end of a journey, but we wish you the very best in the days and months ahead.
Thank you.
Well, Mrs. Ibeka
Thank you very much.
You're welcome. The Special Assistant to the President on Justice Reforms and International Relations, the Office of the AGF, as well as Mr. Ajibola. Thank you so much for your thoughts on the program tonight. Well, that's our show for tonight, everyone. Many thanks for watching. I'm Kayode Okikelu. To have a great weekend.